Good evening. This is a public hearing for a wireless code update, item A-19 on the 2022-2023 development code docket. It is February 7th, 2023. It is 5:32 p.m. I'm Carolina Mejia. I'm the chair of the board. To my right is Vice Chair Ty Menser. To my left is Commissioner Gary Edwards. Also in the boardroom, we have County Manager Ramiro Chavez, as well as Assistant County Manager Robin Campbell and our Clerk of the Board, Jamie Caldwell. The purpose of this public hearing is to accept and consider public testimony on the wireless code update. Those wishing to testify have joined by Zoom, emailed comment, or mailed in comment. If you wish to testify, please visit the Thurston County homepage online and select announcements of public hearings on the left-hand side. The information to join this public hearing remotely has been posted there. If you do not wish to testify but would like to listen and follow along, please watch the live stream through the Thurston County YouTube channel to help us manage attendance. Caitlin Nelson will provide information on this topic. Assuming members of the public on Zoom wish to testify, the county manager will read your name out loud. You will have 4 minutes to testify. Time may not be given to another person. When you're called on, please state your name and address for the record. The clerk of the board will review the timer. The public hearing is now open. Caitlin Nelson will now present background information of the proposal, written comments submitted, and any additional information requested by the board.
Good evening, Commissioners. My name is Caitlin Nelson, Associate Planner with Community Planning. Tonight's hearing is for the Development Code Docket Item A-19, Wireless Communication Facilities. The board directed staff to update code to provide requirements and standards for wireless facilities while complying with federal regulations. The code establishes the permitting process for numerous types of wireless facilities, the criteria for approval, and the design guidelines for each type of facility. This item is a board-initiated proposal ranked as the 11th priority out of 18 Development Code docket items, and the proposed amendments include Chapter 20.03 Definitions, 20.54 Special Use Chapter, and a complete repeal and replace to Chapter 20.33 Wireless Communication Facilities. The Planning Commission held 3 initial work sessions between March and May of 2021 to review and discuss the draft code. A Planning Commission public hearing was held on June 2nd, 2021. In response to public comment, Planning Commission requested the Board of County Commissioners form a stakeholder committee with community representatives. Then on June 23rd, 2021, the board directed the formation of a stakeholder committee with 4 representatives from the community, 2 representatives from wireless providers, and 2 planning commissioners with a set limitation of 3 stakeholder committee meetings. Between October and December 2021, the Stakeholder Committee met 3 times with staff and Thurston County legal consultants. And between February and August of 2022, the Planning Commission held 7 follow-up work sessions. On August 3rd, 2022, the Planning Commission recommended approval of the draft code, voting 5-3 with 1 commissioner absent, and a minority report was provided by 3 planning commissioners. On October 12th, 2022, the Board of County Commissioners reviewed the proposed amendments and process to date, and on January 10th, 2023, staff requested a public hearing be set by the board. On January 12th, 2023, a public notice was published in the Olympian and email notification was sent to interested parties. And on January 31st, a press release was issued on this item. A public notice was published in and then yesterday, a special meeting for Planning Commission was posted on the door and online because we had several Planning Commissioners voice an interest in attending or speaking at this public hearing. We have received a number of public comment on this item, specifically for the comment period for this item. We have received comments from 42 individuals. 3 individuals support wireless infrastructure, and other themes include impacts of radio frequency emissions on health and the environment, testing radio frequency emissions, larger setbacks, standards for facilities in the rights of way, and public notice and comment periods. No action is requested on this item today, and there's also a follow-up briefing on February 9th. And that concludes my remarks. Thank you.
Thank you, Caitlin. Questions from the commissioners? Commissioner Edwards, we'll start with you.
I don't know if my question is for Caitlin or if it'd be the county manager. Are we under a time restraint on making a decision on this? I mean, are we up against federal law or requirements of some kind or another?
We are already behind on this particular code amendment, so additional time the board needs it, I think is appropriate.
Are we in any legal jeopardy at this point because we did not move forward?
Not that I'm aware of, sir.
Not that you're aware? Okay. That's good for me. Thank you, ma'am.
Thank you. Commissioner Menser.
Caitlin, you said that three supported, voiced some sort of support for wireless facilities. Does that mean 39 of the comments were in opposition to this proposed draft, or? You didn't say that, but is that what you meant?
Or voice some sort of concern with the draft, yes.
Some element of it?
Yes.
And, okay, that's all I got for right this second.
Okay. I guess I'll ask a follow-up to Commissioner Edwards' question in regards to what's the risk to the county if we don't amend this code? Or if we decide to take longer or send it back, is there any risk to the county?
That is a very difficult question to answer at this point. What we can probably explore is what is the legal risks that you may have. A third party may be taking any particular action. But again, at this point, I don't see any particular risks other than this needs to be done. It has been delayed for a little while.
You have an additional?
Can I have an additional
Go
question?
ahead, sir.
I guess a follow-up to the chair's question. Well, because of your maybe inability to answer because of the circumstance, we don't know a hypothetical or something like that. At one of our upcoming work sessions involving this or wherever it fits locally, could we have our legal counsel be in attendance at one of our work sessions so we can ask legal counsel that question?
Yeah, we can accommodate that. And again, as Caitlin stated, we have already scheduled a follow-up to this public hearing this coming Thursday. Whether we can accommodate, legal counsel to come to the meeting at that time, we can certainly look into that possibility. And as you know, if you like to have a legal perspective and any particular risks the county may have, that needs to occur in an executive session, not in public. And I can certainly schedule that later on. But again, I think you need to make sure that you have all that information in front of you to make an informed decision.
I guess I would look to my seatmates and do they agree? Is that kind of would that help us make a solution, come up with a solution on this?
I would like to request a session definitely with the attorneys because I would like to know the answer to that question, but I also would like to know just in the public comment we've gotten, right? If we extend those boundaries, I would like to know what's the risk really for the county. If there is any risk at all. So I would like those questions answered. So if we can get some feedback from our attorneys, that would be great. I don't know how.
Yeah, I mean, I think what's going to be useful ultimately for us to get this decided is to have the key issues, and I think there's like 4 of them as I've gone through the different comment. Caitlin actually hit on them and they're on one of these slides. The 4 kind of areas of difference of opinion about what the right policy is. Lay those out, talk about the policy, how have, kind of, I'm thinking of a chart where we have the 4 issues, areas, the policy parameters that could be just chosen or that other communities have chosen, and then a legal risk is each one, Some of them might have a narrow risk to deviate, other one might have a wider risk. If the policy seems like it's an important one, the commissioners might be willing to take more risk. If it doesn't seem to be that important, 6 of one, half a dozen the other, maybe we're willing to take less risk. But kind of breaking it down into those areas with the policy considerations and the legal risk considerations is going to help us just dial in and make the decisions that need to be made. Because I don't want this to go on and on and on, but this is complex and we've got to do our work here to just, balance all the considerations.
Just a quick, and then I'll pass it to the county manager. Just in reviewing the public comment that was submitted, I saw 6 points. So I would like the
Yeah,
6
it
points
depends.
covered, yeah.
Yeah, however you break, one of them was about public comment, one was about public notice. Those could be considered 2 or 1 area. One was, it's 4 to 6, depending on how you, or 7.
I will encourage the board just to go with a public hearing.
Yeah.
For you to hear the public testimony this evening. And then on Thursday, globalizing the conversation based on the written testimony you have received, as well as the public testimony you will be receiving this evening. And then you provide more comprehensive marching orders for me. That will be my suggestion.
Okay. So with that, we'll move on to public testimony. And do we have a sign-up sheet? Thank you, Jane.
Ma'am, while she's getting that, might I make a comment? And I don't know if the public knows this or not, because we're sitting up here together, and you might think that we're communicating on this topic, but we are not. So if we act a little bit like we don't know what the other guy's thinking or whatever, it's true, because under the law, we are not allowed to talk about any county business at any time other than when we are in a public setting like this that's been announced to the public with an agenda, so the public knows exactly what we're discussing at any given time. So I just think it's worth making sure the community knows that, so when you're explaining something to us, we may or may not have heard that before, because we don't get to discuss any of this stuff before we come before a setting like this. So just a point of clarification. Thank you, ma'am.
Thank you. We'll start off with Rebecca M. Campbell.
It has become evident from my telephone and online communications
Ma'am,
with,
can you introduce yourself and where you reside in the county for the record, please?
I was going to do it leaving, but you want me to do it first. All right.
Sir. Yes, ma'am.
Rebecca M. Campbell, 3948 Martin Way, number 266, Olympia, Washington, 98506. May I speak now? It has become evident from my telephone and online communications with the Thurston County government that, among other disturbing revelations, county officials, their staff, and possibly their volunteer commissioners do very little of their own research, at least as of the last year. They largely rely on several outside corporate-connected consultancies for corporate cookie-cutter talking points that we pay for our tax dollars, parrot to the public, and then ultimately use to the detriment of the public in decisions that hurt the public, at least concerning wireless radiation. Although, I will have to say, in your comments that I just heard, there seems to be much more considerate discernment than I thought, so I'd like to commend you on that. So regrettably, I'm here to deliver a warning that I and others would rather not have to deliver, because many of us would prefer to work together amicably with you to resolve what could be a serious crisis unless the objections of the informed residents of these counties are heard and appropriately reflected in your coming decisions as a body on this. Sadly, the main thing we've so far seen is, at least in the draft, seemingly, is our previous comments seem to be ignored. 5G supposedly FCC mandated deployment without recourse and its common state and local excuse, our hands are tied, is based on a mega corrupt foundation of massive state and federal government enabled telecom industry corruption, fraud, and conspiracy largely unknown for 40 years, undocumented, unreported, and unchallenged. That is, until recently and successfully challenged in the federal courts in 2019 through 2020, in the landmark but completely corporate media suppressed federal lawsuit, the Irregulators versus the FCC. This is a massively documented, masterfully written, overwhelmingly winning federal court case that your highly paid corporate consultants and corporate mainstream media probably did not tell you about, but of which we are informing you and can readily provide for your official perusal. In the appendix to these comments, there are web links to this as well as much else that you may, or possibly may not, want to see. Further, Thurston County has the natural and constitutional right of nullification, and I heard this being addressed, of unjust laws and strongly advocated by America's founders and successfully pursued by other American municipalities whose practically principled officials did their own research and drove hard bargains or no bargains at all to stop the dangerous 5G telecom corporate takeover of their cities and counties. 5G wireless is not a cool, next best thing IT tech toy, but a deadly military weapon system, an apex of globalist AI smart grid agenda. The trendy faux green acronym SMART, as revealed by military sources, actually means secret military armaments as residential technologies. This is not just being imposed here in America, if you do your research, but worldwide as well, and there is a potential AI-linked technology of non-nuclear eco-genocide and totalitarian control, reducing our planet to an AI-programmed microwave oven for the ultimate controlled extinction of all life on Earth. And if you want credible in-person virtual eyewitness testimony on this point, we have several credible top experts living right here in this region, 2 of them in Olympia, whom would be glad to speak. Finally, as the telecom industry's catchy 5G advertising placements tend to do, I too would like to end these comments with a hopefully contagious mocking meme on that same corporately managed 5G theme. 5G. The G stands for genocide. Now, I have copies for you. I've got a couple copies, and I have the appendices, the evidentiary appendices on these. So should I just bring them over to you? Okay, and you can investigate these for yourselves, and I am willing to talk further and elaborate on it, but I did a legal action on this earlier, and it's not conventional, and it's going to, and if the courts don't prevail on this, then this can be used.
Please wrap it up. Thank you.
Okay, next is Jenna Shaputi. Okay.
My name is Jenna Shaputis, and I live at 2825 Fish Trap Loop, and that's in Olympia, 98506. So I'm here today speaking out for the fact that there is a massive amount of literature with scientific certainty for pathophysiological effects of artificial electromagnetic frequencies, Wi-Fi in particular. I was familiar with this when Wi-Fi first came to my son's grade school and he came home with vertigo. I ended up pulling him out of school because there was no way around it. Well, that was 10 years ago. And here we are, and not even a year, no, it was February 6th, 2019, when Senator Blumenthal, I watched the program about the issues of the big telecom companies having no biological safety tests for 5G. And Blumenthal said, so we're flying blind? And I'm saying we're not flying blind. We know this is a hazard to our physiological bodies. I have a very good friend and author of this book, Wi-Fi Refugee, The Plight of the Modern Day Canary. There are 3 million Americans in this country that are EHS. This is called electrohypersensitivity. It is a threshold that all of us are affected by, but they've gone beyond that threshold and they no longer can participate in our world. A lot of them are car camping. A lot of them are residing outside of cities. It's like we see the homelessness. Well, the effects of like EHS electrohypersensitivity can biologically break down an entire life. It can destroy a person's life. There are story after stories of people in this country that have endured this, and 5G is just and this was with 3G when my friend was affected back in 2014. So, if the FCC is acting in wanton disregard to human health, I think it's just our local communities that can become aware and actually become accountable to their people. So I want to invoke the precautionary principle based on evidence of harm for this decision-making process. So there has to be a commission. And maybe the later we start, the better it is, because we can see how the rollout is affecting the rest of the country. Risk analysis, assessment, evaluation, and communication, transparency with the public. How is this affecting the other cities that are pushing this forward without any biological safety tests? Dr. Martin Paul, PhD, he is Professor Emeritus from Washington State University, has published a paper online. It's called Compelling Evidence for Great Harm Caused by Electromagnetic Field Exposures. 8 distinct types of health effects, including 4 types of blindness, spontaneous abortion, oxidative stress, free radical damage, single and double strand breaks, mutations in germline impacting all life, trees, animals, insects, lowered fertility, and 15 different mechanisms during cancer causation. Dr. Martin Paul, his papers are peer-reviewed and cited in over 240 scientific journals. Please look him up. It's online. And in fact, when this happened with my son, as soon as I got a copy, I inserted it to the public school system. They have it in their file. Thank you.
Thank you. Next is Mary Abramson.
Mary Abramson, 7833 Burial Court, Olympia, 98513. As you can see, I'm dressed as Lady Liberty because this is about our right to life. And our right to life is not being protected by our federal or state government. So, you are up. It's your job now to protect us. That's what government is supposed to do, is protect the people. 5G is a $20 trillion rollout without a single science safety study, as she talked about. 20,000 peer-reviewed studies worldwide about these biological harmful effects to everything. Bees, birds, animals, soil, and definitely human beings, especially children. We in the Deschutes neighborhood group, Citizens Against 5G Cell Towers, number 129 people. We've been here before asking the Thurston County Commissioners to stop 5G towers because there are no safety studies, none. The captured FCC did not do any, nor did any of the telecom companies like Verizon. 500 people testified, yet the commissioners 2 years ago ruled in favor of a non-person, Verizon. Shameful. We challenged that decision in the Washington courts, who said no. We took our case to the United States Supreme Court, where it was not heard. Currently, we are joined with 150 local communities nationwide with another huge case. Hopefully, the Supreme Court will finally say something. We're finding out that the justice system is now probably captured like our federal agencies are captured, and probably 90% of our federal politicians are captured. So here we are again, a second chance perhaps, your second chance to fulfill your righteous service to protect the health of Thurston County citizens and our wildlife. We are at war. The bioweapons, so-called vaccines, were a genocidal weapon. As more and more people are suddenly dying from the jabs, we're becoming aware. We're in a Holocaust. Unlike Nazi Germany in the 40s, this Holocaust is now global. Please watch the new series, Never Again is Now Global. It just came out last week. Truth is painful. Truth is like a scalpel because it opens wounds that are covered so we can be healed. These lies are what we call the denial system. The denial system protects us for a while from the actual painful, shocking, evil realities. But we must get clean, and that begins with the truth, full awareness. We all must become open-minded and fearlessly open our eyes to see and our ears to hear. Here's the truth as I see and hear it. Earth is a prison planet being controlled by a few people who are blind to their innate divinity. They have become so addicted to power and control, greed and self-importance that they actually formulated a belief system that they were superior to most other human beings when they see who they see as inferior, useless eaters. This Nazi philosophy is called eugenics, which is the sanctioning of murder of innocent humans they view as inferior. After 9 years of heavy-duty state propaganda in Nazi Germany, they finally began the Holocaust by killing, first, little German children, then Germans with disability, next the Jews, because they wanted their wealth and to use them for slave laborers. In the Holocaust, 9 million were systematically murdered. Today, these evil billionaire psychopaths like Gates, Soros, Fauci, with their minions in government, big pharma, big tech, AMA universities, and schools, plan to murder 90% of the world's population, bringing it down to a manageable 500,000
Ma'am,
million.
your time is
They
up.
actually put the goal in the Georgia
Time is
Guidestones.
up. Your time is up.
Your time
Thank
is
you.
My time is up. Your time is up. Our time is up. If we do not realize we're in a war, please get educated. Please.
Thank you.
Next is Dorothy Lyons.
Dorothy Lyons, 4725 Boston Harbor Road Northeast. I understand that the county is updating their code for wireless facility siting permits, in part to comply with new, more industry-favorable regulatory agency guidelines, in which the FCC has far exceeded congressional directives in the Telecommunications Act. However, the proposed code has gone well beyond what is necessary to comply with these already egregious limits on local decision-making. For example, the wireless facilities in most non-residential zones and wireless facilities in any zone proposed for some existing structure require only simple administrative permits with no written advance notice for neighbors, no public comment, no hearing examiner decision, and a loss of opportunity for community feedback that might help the county make a reasoned decision. Even in an industrial area, public comment can potentially provide useful information that might otherwise not be available. For example, a nearby industry may utilize equipment that's highly sensitive to electromagnetic activity. Note that in the county, arterials are residential roads, and a commercial area may be closely surrounded by homes and neighborhoods. Would it not be good to have feedback on specific locations, rather than a blanket approval as long as within the stated zone? Contracted counsel recommended administrative permitting in the many priority non-residential zones to incentivize these areas over residential areas, but the logic is not sound. If filling a significant gap, one location might preclude another. Current code has no justification requirements, such as filling a significant gap, so siting in one area in no way precludes siting in another. Co-location in the proposed code is placement on a pre-existing or modifiable structure, regardless of whether it's already in use for a wireless facility. Wireless communications facilities in any zone proposed for attachment to an existing structure are all eligible for administrative approval, even, for example, a building-mounted cell facility in a residential neighborhood. I do not believe this would be the intent of either the planning commissioners or the county commissioners or the desire of the residents of Thurston County. Many suggestions made by the public portion of the stakeholder group were largely dismissed as outside the purview of the Planning Commission. We were given to understand that the county commissioners would need to make decisions of potential legal consequence or that would incur expense to the county, such as public comment within short timelines or random testing of cumulative radiation levels to verify FCC compliance. We expected that beyond the conservative base code recommendations, the commissioners would be presented with clear options related to issues determined to need county commissioner attention that did not, to my knowledge, occur. I'm here to ask that the wealth of comments that you've received be seriously reviewed along with stakeholder recommendations. I hope the code will be reevaluated in a good faith effort to incorporate more public protections, public communication, and transparency, or to present specific options as to what that could look like to the county commissioners. There is a better balance possible. Other communities have prioritized public rights, so can we. I've lived in Thurston County for 42 years and been proud of the county's efforts to support its residents in the environment we live in. I hope to have reason to continue to hold on to that pride. I'd like to finish by including a small indication of community support for code improvements. Please know that a petition only recently made available and now growing had, as of 10 a.m. this morning, signatures from 167 county residents, an additional 16 out-of-county Washington residents, and another 65 out-of-state supporters. The petition details and signers as of this morning were submitted as written comment. Lastly, I just want to thank you sincerely for your efforts on behalf of us all. Thank you.
Thank you. Next is Josh Stottlemyre.
Good evening. Good evening, Commissioners. My name is Josh Stottlemyre, unincorporated Thurston County, 98501. Was a member of the Wireless Stakeholder Group and founder of Thurston County Citizens for a Sensible Wireless Code. I do not have time here tonight to even scratch the surface of the issues with this code. A thorough review of the written comments is necessary to understand the issues. You will find them informative and beneficial to your considerations. I ask that you do not make a decision without personally reviewing the written comments in detail. Staff summaries will not be adequate to understand all of the issues here. If you've reviewed the recommendations from the citizens on the Wireless Stakeholder Committee and compared them to the draft code before you, you know that virtually none of the recommendations were integrated into the code, nor were any of the things overwhelmingly asked for by citizens in the first comment period of the Planning Commission. The most common requests included required notice, public comment, increased setbacks, and testing all facilities. While these things are the most important, addressing them alone is far from an adequate solution to what is frankly a horrendous code. There is hardly a section of the code without concerning implications for public safety, aesthetics, local control, and property values. Addressing these issues will in no way prevent wireless providers from providing services throughout the county. Over the past 2 years, myself and other concerned citizens have dedicated hundreds of hours to studying the code, FCC rules, federal law, and researching legal solutions. What we learned was compiled and submitted to county staff during the stakeholder meetings, including a legal review of the draft code prepared by a highly experienced wireless attorney. Then we were told in no uncertain terms that the materials were not looked at and would not be looked at. The reason? Guardrails. The stakeholder group was not to discuss anything of legal consideration. As you know, the entire code is of legal consideration. We were told instead to focus on policy considerations. We then came up with a priority list of recommendations and the policy considerations. These were initially accepted by staff and very briefly summarized to the Planning Commission. Then the guardrails expanded. This time, despite being given no such direction by the BoCC, the new expanded guardrails were applied to the Planning Commission. These guardrails did not allow the commissioners to discuss anything that had legal consideration, would result in increased staff time, could have potential costs to the county, or if it involved rules for wireless in the right-of-way, one of the main purposes for this code update. In other words, the guardrails tied the hands of the Planning Commission regarding every aspect of this code of real consequence. The staff stated that any changes in these areas of the draft would have to be made by the BoCC. In a further breakdown of process, the BoCC was not presented with options or information on which areas of the code that exceeded the guardrails to which they would need to pay special attention, due to the Planning Commission being prevented from considering them. Alternatively, according to staff, prior to any public hearing, the wireless industry had, and I quote, direct input into the draft code. In addition, the requests industry reps had during the stakeholder meetings, such as macro facilities in the right-of-way, were also integrated into the draft you see before you. The Planning Commission did not ask for these changes. Public comment did not support them. FCC rules and federal law do not require them, yet they were added to the new draft. I'm almost done. Having reviewed dozens of wireless code from large cities, small towns, and everything in between, I can say that the draft code is one of the most favorable to the wireless industry I have seen. And I have come across none that are worse and very few that are as bad. I'm dedicated to this cause because it's the right thing to do. The very same reason you should direct the staff to make citizen-supported changes to the code, you should also enlist the services of a wireless attorney that has experience representing and protecting people and their property values. Thank you for your consideration and your service to our community. Please refer to the written comments for specific code recommendations. Thank you.
Okay, next is, I know Stephen Michigan said no, but want to give them a chance. No? Okay. Christy White.
Good evening, Commissioners. I live in the Delphi Valley of Thurston County. I represent to you this evening as a citizen member of the Wireless Stakeholders Committee and have lived in Thurston County for over 25 years. The wireless code affects every citizen in the county. If a diesel generator is put in the right-of-way adjacent to your home without your consent, and the company says, "We monitor and make everything quiet and safe. Don't worry, it is fine," what would you think about that? Would you trust it? I believe you would insist on a very detailed code written to protect your home and family. Diligence must be applied to our wireless code. If it is not written into the code, it means nothing. This code can protect citizens of Thurston County without impeding the industry's economic development. This requires the Board of County Commissioners implement a defined, protective, and fair code. As a homeowner, I have the right to determine the technologies that impact my home and property. This code does not allow me that choice. Our asks are reasonable. Larger setbacks from our homes, schools, and businesses for all facility types, including those in the right-of-way and co-locations. Public notice of a new facility, public notice of applications, public comment on all new facility applications, radiation compliance testing by the county or an independent party, no new macro facilities in the rights-of-way. I ask that you do not adopt this current code and adopt the citizen recommendations by the Citizen Stakeholder Committee, Josh Stottlemyre, and the City of Langley, another responsibly written code, along with the City of Petaluma, California. The board's mission is to create a community that promotes health, commerce, and environmental protection with transparency and accountability. Many words you will probably hear tonight are not from those who live here. I hope you will remember the requests of those who do live here and of whom you represent. The changes to the code have been provided to you, the Planning Commission, and the Planning Department by the citizens of the Stakeholders Committee. The minority report submitted to you from 3 Planning Commission members is telling in itself. The wireless code passed in 2022 in Washington State and the City of Langley is attached to my comments this evening. You do not have to create the code from scratch. The Langley Code, like others in this country, are thought out and detailed. I specifically point to the Langley Code, paragraph 1823-30. It refers to the balancing of interests, which references local control. It is the responsibility that Thurston County follow the example of Langley and other codes. I appreciate the opportunity of creating our stakeholders group. And I really hope that, as to echo what Josh had said earlier, that you look into the detail and look at other possibilities for information and reference. Thank you. I'll provide my comments to you.
Thank you. Next is Kevin Pestinger.
My name is Kevin Pestinger. I live at 1172 Willow Street in Lacey. I am a member of the Thurston County Planning Commission. I'm not here speaking to represent the Planning Commission, but I am the one who wrote the minority report that was signed on to by 2 other Planning Commission members. And I'm happy to discuss why I wrote that as part of this comment. I would participate. I've been on the Planning Commission for about 1.5 years, and I participated in most of these work that was done on this wireless update code. I was surprised at the way that the whole process sort of unfolded and the sort of process that followed, everything from public outreach to the working sessions to the way the consultant had been hired and the way the consultant was in control of the conversation and the way that the consultant often dictated to the group what we were allowed to talk about or not talk about or consider or not consider. And it really felt like a miscarriage of public process. And you just heard from 3 people who were part of those work sessions, Dorothy and Josh and Christy, and they are a big part of the reason that I'm here. They were wonderful to work with, and their testimony that they just provided is incredibly articulate and very well said, and I agree with 100% of everything they just said. And I wrote this minority report and included some strong language, including calling out the consultant as being more in the interest of the wireless industry than in the interest of the public of Thurston County. And I drew the ire of one of my fellow Planning Commission members who at the last Planning Commission meeting let me know that they did not like I stated things like that. I also stated that the Planning Commission didn't fully listen to public comment in terms of what we recommended and put across as an end result. And I think I'm certain that I stand by all of my statements in the minority report, but I think a little context and a little clarification probably helps. In that example of saying that the Planning Commission, the majority of the Planning Commission didn't fully listen to public comment, I'm not saying they didn't listen to things that were said. This is actually, the Planning Commission as well as the Board of County Commissioners are probably 2 of the best local agencies in Thurston County, including even our legislature, at listening to public comment. I actually commend both of these organizations very highly for that. But what I mean is when there's a range of options and they could include just leave the code as it is, no changes in terms of setbacks, for example. And that current setback limit in one instance is 25 feet. And we know that other cities have regulations or counties have regulations for 50 feet, 100 feet, 200 feet, even 1,000-foot setbacks. We know all of these are possible under the law. But the county commissioners hear from all of the public, we want much bigger setbacks. We want, under different circumstances, we want different levels of setbacks, but we definitely want more than the minimum. And the wireless consultant says, for the county says, nope, I'm unwilling to make any recommendation for anything other than that 25-foot minimum. And therefore, because I've said that, then the staff refuses to research or provide recommendations. So then the other planning commissioners throw up their arms and say, this is too complicated. We can't come up with a recommendation if staff won't even help us research what a good option would be here. And that was the way we got to not really listening to the public. So I strongly encourage you to either follow Josh's recommendation of the codes he's provided and the City of Langley's codes, or send it back to the Planning Commission. We have gotten better as Planning Commission
Let's wrap it up, sir.
in terms of our ability to operate and have a better process, and we can do a better job of implementing and integrating public comment and public concerns into a proper recommendation rather than this simple rubber stamp. Thank you.
Thank you. Next, I have Amy Stottlemyre.
Hello, Amy Stottlemyre, a resident. I live by Miller, Sylvania State Park. Without a detailed understanding and familiarity with wireless code, it is difficult to grasp all of the issues, considerations, and consequences of the draft wireless code. Further, the draft relies on sections of the county code which are not being updated. Those sections were written without consideration for wireless facilities, yet are being relied upon to control, for example, wireless facilities in the right-of-way, setbacks, public notice and comment, just to name a few. You must review the written comments, wireless stakeholder recommendations, varying legal opinions, and codes from other municipalities, which I will give you some more besides the Langley Code, ranging from the most productive to the least, to understand the issues at play here and options for addressing them. Verbal comments in a 30-minute staff presentation alone will not provide that. Citizen comments and petitions submitted for you ask for, at a minimum, significantly larger setbacks from our homes and schools for all facility types, including those in the right-of-ways and co-locations. Public notice of new facility applications, public comment on all new facility applications, radiation compliance testing by the county or an independent party, no new macro facilities in the right-of-way, design and locating standards with protections for the public and for property. However, that is far from a complete list of concerns with this draft code. A few of the less obvious but equally concerning issues with the draft code include the ability of staff to override a code at their sole discretion, the ability to mount wireless facilities on literally anything and call that a co-location, exempting them from any rules, inadequate noise limitations, virtually no rules for small wireless facilities in the right-of-way, including be exempt from safety considerations, non-existent design rules, allowing facilities as close to 10 feet from a home with no meaningful notice or the ability to comment, no need to verify structural safety in most cases, no actual testing of radiation emission compliance or verification of FCC compliance in general. Simple attestations are considered adequate. And that's not everything. The list goes on, but obviously a minute and 30 seconds, can't do that. Some well-developed, populated municipalities, as Christy mentioned previously, the Langley Code is a great example. Petaluma, I believe she mentioned, but also there's Mill Valley, Palo Alto, Santa Barbara, and San Diego County, just to name a few, have implemented much more comprehensive and protective codes. All of these are prime territory for the wireless industry, and they have not been sued. So if we're worried about being sued, those are excellent places to look into, because everything they're doing is legally defensible. Unincorporated Thurston County is very low on the wireless industry's list by comparison. These codes represent other legally valid interpretations of federal law and FCC rules. The interpretation of your staff and consultant, as seen in this draft code, is just one of many. Further, FCC rules are only the FCC's interpretation and expansion of the federal law Congress made. Municipal wireless codes amount to an interpretation of federal law. Why are we only relying on the interpretation of one consultant to write our code when clearly there are other varied and valid interpretations that do a much better to serve the interest of your citizens? I'm skipping some stuff. The Planning Commission Minority Report stated that there was a complete breakdown in the process, called for a different unbiased consultant to be brought in, and to reconsider all public comment and citizen recommendations. I urge you to follow their advice. Thank you so much for your time and consideration.
Thank you. Next, I have Michelle Horkins Brigham.
Oops. My name is Michelle Hawkins Brigham, and I live on the outskirts of Yelm. And hello, commissioners. So the last time we spoke was in regards to the public and environmental health dangers of land-disposed toxic sewage sludge. Commissioner Edwards mentioned it would be up to the next generation to do something about the issue. Commissioner Edwards, I am gifting you Sludge Tracker as an outcome of that Zoom meeting. We should wonder if the next generation will also be needed to clean up an equally devastating public health concern, the results of debilitating electromagnetic frequencies emitted from powerful wireless facilities stationed all over the countryside. I am opposed to this wireless update, and I say no to this draft ordinance. I do not use a cell phone. I have a landline. I do not want my family harmed by EMF radiation from antennas surrounding my home. Radio frequency emissions are mentioned, but why is there no reference to protecting the public from the dangers of EMF bombardment? In my view, this proposed draft gives loosely controlled license to wireless facilities to be placed almost anywhere and on anyone's doorstep while smothering our beautiful county in ugly stations, regardless of stealth, an interesting word choice, and EMF fog. No reference is made to any of the short or long-term public health concerns associated with this industry. As some commissioners may remember, it took a huge effort and cost to my family to convince the county of abuses incurred from a prior interim ordinance regarding the marijuana industry. Negative impacts to communities were not wisely considered at the time. 10 years later, and despite many complaints of excessive noise, loss of neighborhood character, lack of visual aesthetics, no setbacks or vegetative screening, and other non-enforced land use issues, the impacts of that ordinance still plague us. That's just one example of inadequate county oversight at just one property. How then will the county manage, in the best interests of the public, the safe placement and oversight of thousands of wireless facilities? Will they monitor the residual health effects from all of these antennas over time? In my opinion, such wireless facilities are not safe within 10,000 feet of a residential building. At the very minimum, a 2,000-foot setback should apply to all property boundaries. So much of the wording in this draft appears to support the wireless industry, even to the point under A, completeness review, and I quote, if the application is not reviewed for completeness within the applicable time frame, 10 or 30 days, it will be deemed complete, end of quote. What opportunity does one have to counter an application they were never informed about and within only 10 or 30 days? And even then, the language indicates the site would still be approved. Preposterous. All neighbors within 1 mile of a planned wireless facility should be notified prior to any application being presented and given 90 days to respond. Individuals with immune deficiencies or intolerance to EMF, such as sleep deprivation, should prevent antenna placement in that area. If you hold a cell phone to the side of your head, you can feel the emitted heat penetrating your ear.
Thank you. Next, I have Helen Wheatley.
Hello, Commissioners. I'm Helen Wheatley, and I am a member of your Planning Commission, but I am speaking on my own behalf. I'm from Olympia, Washington, although I am speaking a little bit from experience on, working on this as a relative latecomer to the Planning Commission. I want to echo the observation made numerous times about the, I would call it the overzealousness of the consultant to avoid risk of any at all costs, based on a theory, I guess, that the county would be at a great risk of liability or being sued by carriers, et cetera. And that became a topic of discussion. And I tried very hard to understand where the risk was. And it became clear that in many cases, what you need to look at is the question about what would the remedy be? You know, if the county were found to have been too harsh in its regulation, and if the carriers were to make a case against the county, what would their remedy be? And it would be simply to be allowed to do what it wanted to do under the FCC rules. So that's not much of a risk to the county. So when you're discussing the legal implications of this stuff, please ask those questions. You know, when you're thinking about the relative risks for the county, what are the risks of not regulating well enough versus the risks of being sued by a carrier? It's a really important question. And in that regard, what I had actually wanted to bring up was something related to that. When I began to look at the wireless code update as a newcomer to the Planning Commission, I tried to compare the new language with the existing language, and one thing that really struck me was the complete change in the purpose statement. And one thing that I noticed disappeared was any mention of protection of public health and safety, let alone environmental health and safety. There's mention of promoting tourism, there's mention of protecting property, but health and safety isn't there. And I was given the understanding that it's not legitimate to talk about that. That was the understanding that I personally came away with, that couldn't be part of this code. I think it can be. I think it should be. I think the county's main concern should be protection of the citizens and the environment, and not its liability should the carriers decide to sue the county, you know, especially if you consider the remedies that the carriers would have. So, I mean, that's kind of the big point I'm trying to make here is I think that you might really want to look at the purpose statement, and you might want to think about, and this was very hard to parse, what is actually being required as a change under those FCC code changes, and what is discretionary in this proposed code. I really struggled with that. I think there's a lot more discretionary change in here than was kind of implied or that I was given to believe. And you're hearing a lot of that testimony now from the subcommittee. And so I would certainly, as a planning commissioner, welcome bouncing it back to us. I think with some direction from the council that public health and safety is important and alternatives should be explored. Thank you.
Thank you. And then the last person I have signed up is Lori Lively.
I'm Lori Lively. I live in South Cap neighborhood in Olympia, and have for about 10 years. I feel like it's a really important thing to be the last person to speak, and I can only hope that I can summarize some of the comments in a way that is convincing or really gets at the heart of this matter. I want to first thank you. I'm pleasantly surprised at the openness of this process. It makes me feel a little bit better about this very concerning code. And I hear the commissioners when you talk about your concerns about whether or not you need to resolve this issue, whether you're going to come across time constraints, are you violating anything? I guess the unspoken part is, as several have mentioned, if it's also a question of whether or not there's a concern about being sued later by a carrier for not going with the industry recommendations, which as I understand are actually far more at your discretion than they would lead you to believe. It's disturbing that the stakeholders' comments were not taken into consideration after the extensive work and research that they have done on that. So I do hope there will be an opportunity for you all to look again at those comments. And the minority report is a further wake-up call that you have another chance to make this right and not be so motivated by fear that is likely not to materialize, as in a legal backlash from the telecom industry. As others have mentioned, Palo Alto, Santa Barbara, Petaluma, none of these places have received any legal pushback for their cautionary choices. And so, I guess I would just say I agree with almost everything that has been said here. And this is an opportunity I hope you all will take up in earnest to err on the side of caution for public health. It's very concerning that the language just disappeared from the code. The purpose statement that, health and safety are completely absent from it now. So I encourage you to read between the lines and err on the side of caution for the constituents, the people you work for, us, and our land and our health, rather than a captured agency and industry representatives who have their own bottom line at heart. Thank you.
Thank you. Is there anyone else in the boardroom who did not get a chance to sign up that would like to go at this time? Okay, County Manager, can you assist me with Zoom, please?
Yes, and I will call your name based on the order that I have in my Zoom screen. And I have an electronic watch so you can see your time. First on my screen, I have Ms. Louise Gilman. Next, I have Ms. Cheryl Powers.
Hello, I'm not going to speak. I was here as an interested and concerned citizen, and I really was quite impressed by the points that were made by the people who spoke. So thank you, but I'm not going to do my own speech today.
I go back to Ms. Louise Gilman. Please unmute yourself. You have 4 minutes.
My name is Louise Gilman. I live in Tenino, and I've lived in Thurston County for about 30 years. I will be providing a high-level summary of the biological effects of exposure to non-thermal microwave electromagnetic frequencies, EMFs, from 5G, 4G microwave towers or facilities, as you call them. These radiation effects are also caused by cell phones, Wi-Fi, Bluetooth devices, remote telephones, and smart meters, which I will not cover here. Following is a list of biological effects excerpted from a document authored by Dr. Martin L. Paul, PhD, Professor Emeritus of Biochemistry and Basic Medical Sciences at Washington State University. The document is called 5G, the Scientific Perspective, and is included as an attachment. Dr. Paul is recognized as a world-renowned expert in the biological effects of low-intensity radiation. I strongly suggest that you read the complete, well-researched and referenced document written by Dr. Paul. The cell phone companies have only provided data regarding thermal effects of cell phone radiation in studies that were designed poorly to placate the FCC and public into believing that these microwave EMFs are safe. However, there is a plethora of independent scientific studies that identify 8 pathophysiological effects caused by non-thermal microwave EMF exposures. Dr. Paul's paper includes 12 to 35 study reviews on each specific effect. The cell phone companies and FCC have ignored these independent studies, many times discrediting the scientists and damaging their reputations. These EMFs, number one, attack our nervous systems, including our brains, leading to widespread neurological, neuropsychiatric effects. For example, sleep disturbances, insomnia, fatigue, tiredness, headaches, depression, depressive symptoms, lack of concentration and attention, cognitive dysfunction, dizziness, vertigo, memory changes, and restlessness, tension, anxiety, stress, agitation, and irritability. Number two, attack our endocrine, that is hormonal systems, leading to some abnormal increased and decreased hormone levels. Number three, produce oxidative stress and free radical damage that have central roles in essentially all chronic diseases. Number four, attack the DNA of our cells, producing single strand and double strand breaks in cellular DNA and oxide bases in our cellular DNA. These in turn produce cancer and also mutations in germ-line cells, which cause mutations in future generations. Number five, produce elevated levels of apoptosis, which is programmed cell death, that cause both neurodegenerative diseases and infertility.
Please wrap it up, ma'am. Your time is up.
Okay. Thank you.
Thank you. Next, I have Mr. Terrence Danish. Please go ahead, sir. You have 4 minutes.
Thank you. I don't have any comments.
Okay, thank you. Next, I have Merdi Pabst. Next, go ahead. You have 4 minutes if you would like to provide testimony. Next, I have Kim Allen.
Good evening. Can you hear me?
I'm sorry, sir.
Go
Oh,
ahead, you have 4 minutes.
I'm sorry. Can you just return to Meridi, please? I had a technical issue. Kim can go ahead and go first.
Yeah, I'll call you next. There, go ahead, Ms. Allen.
Okay. Good evening. My name is Kim Allen. I am here representing Verizon Wireless this evening. I'm with the Wireless Policy Group. I appreciate the opportunity to testify on these regulations for such an important technology. The technology and the expansion of the network that these regulations will assist will allow the part of daily life that requires devices and wireless connections to carry more data, to work with more speed, and to serve more customers. I served on the stakeholder committee as one of the 2 wireless representatives. The process was detailed. It was spread over a number of meetings. We spent many hours in an iterative process, and I do want to comment that the staff and the consultant did place guardrails on the discussion and on what would be possible, but those were based on the fact that a large area of this regulatory field has been preempted by federal law. There are areas in which local municipalities, such as Thurston County, simply cannot regulate. For example, I know that the health effects of radio frequency emissions has been mentioned. That is an area that has been completely preempted by the federal government. The FCC says that local governments cannot consider that when they are regulating the wireless facilities. The time constraints that we have heard about and the deadlines that are there are also set by federal law. There are very strict shot clocks or time deadlines, some as short as 60 days, with resulting in a deemed granted remedy by federal law. So a lot of the code that you're seeing tonight incorporates very, very common federal regulations. The code is not an outlier for other Washington jurisdictions. I've worked on dozens and dozens of codes in the state of Washington. Thurston County is kind of late to the game. Most of these code changes occurred between 2018 and 2021. I've been working on the Thurston County code update for since about 2018 or 2019. And we've had an enormous amount of public process for this code. In terms of some of the specific issues addressed by the citizens, in terms of setbacks, cities in Thurston County that have recently updated their wireless code to comply with federal law have not required setbacks for small wireless facilities in the right of way. I've looked at Olympia and Tumwater as the two major cities that did code updates recently. And the reason is that small wireless facilities are low power, the signals don't go very far. And if you were to impose 1,000-foot setback, and that's over 3 football fields in length, the signal simply couldn't get from the right of way to the house, which is where the service is intended. No home, or very few homes have setbacks that are 1,000 feet typically. So it would be very difficult for us to be able to serve those homes and to bring them the service that they're looking for. And then also some of the cities that were named Petaluma and Palo Alto and San Diego County, they have been the subject of lawsuits, maybe not taken to conclusion, but they have been sued. And those regulations have been found to be overly restrictive and results in an effective prohibition of service when they are applied. So there is legal risk to the county. I understand that you're going to consult with the county attorney. We want to bring the best service that we can to the residents and businesses of Thurston County. And to do that, we need to have the infrastructure that will carry the data and the service that your residents and businesses are requesting and frankly depend
Please
upon.
wrap it up, ma'am.
Thank you.
Could you, for the record, could you state where you reside in the county?
Oh, I reside in Kitsap County on Lala Cove Lane.
Next, I go back to Ms. Murdy Potts. Go ahead, 4 minutes.
Yes, thank you very much, and sorry for the issue there. Good evening, Chair and Commissioners. My name is Meredith Pabst of Bush Law Firm, and I'm speaking on behalf of AT&T. AT&T understands that an ordinance like the one before the county's board tonight is a balancing of multiple interests. And I'd like to speak a little bit about AT&T's perspective. I think there's a misconception that that industry representatives drove this code change. We certainly asked and prompted the county to update its code, but the draft was prepared by staff and the county's consultant with a history of representing municipal entities. AT&T submitted comments on the draft when it was released in early April 2021, and many of its comments were not adopted by staff. As an illustration, I'd like to speak to setbacks for towers as they're proposed in the new code. First, in residential zones, the code requires a tower height setback from a property line. This is a very common way of measuring setbacks in a wireless ordinance, and AT&T sees it all over. But in addition, on top of that provision, the proposed code in zones that allow residential uses requires that a new tower be at least 200 feet from an offsite residence. So this in effect could require an even greater setback from the property line. For example, if the neighbor's home is close to the shared property line, then the tower will have to be moved further deeper into the parcel. When AT&T commented on the proposed draft, it suggested that this provision be deleted. It's not a customary provision. It adds an additional setback that AT&T doesn't see everywhere. But staff declined to accept that change, and it remains in the code. So from AT&T's point of view, the county's proposed setbacks are offering more protection than is typical. Some citizens below and in comments since then have advocated for setbacks of 1,000 or 1,250 feet. And in this context, another issue to be mindful of is whether the community will receive adequate communication service with such a restriction. This is because a large setback can easily eliminate all siting options in an area. For example, if I were to propose a tower and then draw a circle around the tower with a 1,000-foot radius that would be consistent with 1,000-foot setback, the area within that circle would be more than 72 acres. And especially in areas where there are smaller parcels in and near urban growth boundaries, it would be nearly impossible to find a parcel of an adequate size to meet such a restrictive standard. So again, AT&T supports a balanced approach. I would finally like to note that the county has had a wireless ordinance for years now, and this proposed code is not a radical departure of from the code that's been in effect. There are several updates for consistency with federal law, a lot of them procedural, and that has to do with modifications to existing facilities and some with small cell proposals. But again, this carries over policy that the county has had in place for decades. Thank you very much, and I'm happy to answer any questions you may have.
Point of order.
No, sir. No, sir.
You have to move on and then we
Yeah,
can address
next I
questions.
have Ms. Connie Anderson.
As a point of order.
No, sir, excuse me.
Ramiro has asked everybody to say their address at the start. He even interrupted the first speaker 3 sentences in, and yet we've got 2 people from outside the county who are not asked their
They
address.
represent the industry which they're entitled to provide comments to the board.
And should provide their address for the public record.
I believe the representative from Verizon said they were from Kitsap County. And then I did not hear where the,
G&T person, yeah. So we can follow up.
Yes, and that's my mistake. Meredy Pabst. My mailing address is 2728 North L Street, Washougal, Washington, 98671. Thank you.
Ms. Connie Anderson, go ahead, you have 4 minutes. Next, Ms. Sue Denver, 4 minutes. Next, Ms. Lauren Polini.
No comment, thank you.
Okay, and last, I think, is the media is Cairo 7. I don't know if you'd like to provide testimony, but you're welcome to do it. And I believe that will conclude public testimony, Madam Chair.
okay.
Can you hear me? This is Sue Danver.
Yes, ma'am. We'll go ahead and take her public testimony.
Go ahead, ma'am. You have 4 minutes. I don't have the clock up, but I will give you a cue 30 seconds before your time's up.
So you're talking to me, Sue Danver?
Yes.
Go ahead. You have 4 minutes.
Okay, thank you so much. Well, I come to this meeting and I find that we now have 4 minutes rather than 3 And I want to thank whoever made that change because it makes commenting much more reasonable. But I prepared my comments on wireless under the operating rules that I experienced at the Planning Commission, that I could not talk about health, which is of my concern, but I have not had time to prepare my comments. I do have sort of a eclectic collection of comments. Recently, I received notice that a Dr. Manville, who used to be the U.S. Fish and Wildlife Service head on cell towers, has recently published a 134 page paper on the health effects on wildlife. I didn't focus on that because I didn't want to even touch that comment. But one thing I did see is that it affected many of the things that Louise Gilman mentioned, DNA, etc., nesting behavior, etc. I would like permission to hand that in if we now are allowed to talk about health in wildlife, which I think you can.
You still have the time, ma'am. Go ahead.
Yeah, I know. I'm skipping around because it broadened out suddenly. I did receive good news. I did do a written comment, and I'm building on that. I had good news today, though. Something that no one has brought up, that is that there are alternatives to towers. I learned that the Nisqually tribe hardwired their entire community. And since then, they have expanded to offer that service of providing hardwire to other outside the community. This is a cheaper way to do it and a safer way to do it, to provide hardwiring service. So there are alternative solutions. What else? I just also want to mention that technology changes rapidly. And I just learned this afternoon that the driving force for 5G, and this is subject to your research, could be caused by the need for driverless cars. But that hasn't taken very well. And so, and also 6G is now being developed. It operates according to my source. Again, you need to do the further research, but that operates at a different wavelength and doesn't need the 5G towers, which immediately said to me, oh, so we're
30 seconds, ma'am, 30 seconds.
Okay, that the 5G tower that has been constructed maybe in a very dense grid work in our neighborhoods against our desire, who will take them down? Is that in your code? Are we responsible for taking down these towers? Will, or SWFs as they're called, or will we have them in our yard until we dispose of them?
Please wrap it up, man. Your time is up.
So I do think that I agree with others that the code is inadequate and should be improved and visited again. Thank you very much.
No, I believe public testimony has been concluded, Madam Chair.
Okay. Thank you. Okay, so with that, are there any discussion items the board would like to touch on this time?
Yes, ma'am.
Commissioner Edwards, go ahead.
When we do get into our additional briefing on this particular topic, could you make sure that council that comes with you at least has some knowledge about this regulators versus FCC or something, so they at least can comment on that in some fashion or another.
Any discussion, Commissioner Menzer? No discussion items for me. I would just like to thank members of the public who have come and provided public testimony today. With that, the next action item is to close the public hearing. Are we, commissioners, ready to move forward?
I'll move to close the public hearing.
Second?
Been moved and seconded. Any discussion?
No, ma'am.
I'll call for the vote.
Commissioner Edwards?
Aye.
Commissioner Menzer?
Aye.
Commissioner Mejia?
Aye. The public hearing is now closed. As a follow-up, a briefing is scheduled for this item on February 9th at 1:30. And it is only a half-hour briefing where we'll probably touch on some items. So with that, we are adjourned. Thank you all very much.